Thanks very much. Can everyone hear me? Yes. Okay, great. Good afternoon, everyone, and thanks for being here. I'm really excited to chair this panel. My name is Vikram Kumar. I'm a principal at Cornerstone Research. I've been an antitrust economist for the past 10 years and have been working a lot on class action matters recently, and also have been doing some privacy-related regulatory work in front of European data protection authorities. With me here today is a panel of other economists, and I'll let them introduce themselves.
Hello, my name is Asger Lund. I'm a partner at Copenhagen Economics and a professor at University of North Carolina, Chapel Hill. Before joining Copenhagen Economics, I worked in academia for several years in econometrics with a focus on modeling and financial markets. I did also an occasional expert geek. So far, I've done a fair amount of work in competition and antitrust, but the majority of the work that I'm doing is within dispute resolution and damage quantification. I've been involved in several cases around Europe, and I should probably disclose that I am active in trucks proceedings on claimant side, given that we will be talking about that today. I'm also involved in other cases around Europe, both are instructed by claimants and defendants.
Hi everyone, my name is Mark Bosley. I'm a director at Berkeley Research Group. I am an economist and also a chartered accountant, and provide expert advice to both claimants and defendants in competition litigation, and in particular I'm involved in several ongoing class actions before the Competition Appeal Tribunal in the UK.
Thanks. My name is Felix Hammeke. I'm a director in the Alex Partners economics practice here in London. I do work across Europe, mostly the UK and Germany, and I'm involved helping some of our partners on the defendant side, on the various interchange cases that are being brought, including the CPOs, as well as on the claimant side for the App Store cases against Google and Apple, as well as the trains cases, the boundary fair cases.
Thanks very much. Okay, so diving right in, you're all familiar with the fundamental building blocks of quantifying damages, and the objective in these cases, of course, is to compensate claimants for whatever breach that has occurred. And obviously a fundamental aspect of this is going to be thinking about what the actual and the but-for world or the counterfactual worlds are. So Mark, just coming to you first, did you have are there any reasons why class actions in particular are special, or what's special about them when you think about these issues?
Yes, absolutely. Thank you very much. I think class actions are special in a couple of ways. So starting with the basic framework, the framework is common, but I think the application is slightly distinct. And I should preface these remarks by saying I am talking principally about competition class actions before the Competition Appeal Tribunal in the UK, which, as we'll come back to later, is a separate legal regime, and actually some of what I say doesn't apply to other types of matters. So the basic framework, as Vikram said, is compensatory damages, that is damages that put the class members back in the position they would have been but for the alleged wrongful act. And that's familiar to us all. What's distinct about the competition actions before the CAT is that that is applied at the class level and not at the individual level. And that makes a real difference. It was explained quite nicely by the CAT recently in one of their judgments on the Govia Thameslink case. They said individual loss need neither be pleaded nor proved. It is enough to plead and prove class-wide loss. And rather flatteringly, they went on to say this places the expert economist centre stage. Here we all are. And they said the effort and cost of demonstrating a class-wide loss based upon a general and class-wide theory of harm will generally be far less than seeking to establish and aggregate a series of individualized claims. And I think that's important. I mean, I might even go a little bit further than the CAT and say that framework moves many of these actions from being impossible to being possible. A second point of difference, a thing that makes class actions or competition class actions special, relates to the types of claims that we're starting to see. So competition litigation has traditionally been principally what's called follow-on actions, actions following on from a decision by the competition regulator. And we have some class actions like that that are follow-on or quasi-follow-on, the Merrick's, the RHA Trucks class action, the FX class action. But we also now have a lot of standalone claims. A standalone claim that hears the liability, i.e. the breach of competition law and the quantum of damages at the same time. Very normal in commercial disputes, but distinctive here and creates some challenges for us as economists, because normally we're preparing these actions with the benefit of the competition authority's investigation, their assessment, and all the evidence they've gathered. Bringing these actions without all that evidence beforehand is more difficult. In particular, we don't have the CMA's statutory powers. We also have duty of independence. We're not an investigating or prosecuting authority. So that is an extra challenge and a little bit of extra color to that in terms of bringing actions without the CMA's involvement is, on most of these cases, it doesn't seem that the cavalry is going to arrive in the form of the CMA either. In a recent speech, actually, Sarah Cardle said quite specifically that in relation to their case prioritization, they will take into account the involvement or the existence of private enforcement. She compared the hypothetical two cases, one with private enforcement, one without, and said, we may take that into account, potentially leading us to launch public enforcement in the case with no overlapping private action. So they're going to leave us to it. But I think that does create some challenges for us that in our methodology that Felix is going to expand on.
Thanks very much, Mark. I just want to dig a little bit into specific requirements that the CAT is trying to impose on experts on claimant side, and in particular, one of the things that's often talked about is the Microsoft process test. Could you, that test of course draws upon a judgment that came out in Canada. So could Felix, could you just talk a little bit about what the test is and what that's ended up implying for claimant experts?
Yeah, thanks. So I think the way I understand the test, how it applies here, is really the tribunal giving us experts a clear structure saying you need to have a methodology that's going to bring us from the CPO application stage all the way to the trial and the award of damage. And just to quote what the test actually means, according to the Canadian Supreme Court, is that the experts must offer a methodology that has a realistic prospect of establishing loss on a class-wide basis, and that methodology cannot be purely theoretical or hypothetical, but must be grounded in the facts of the particular case. And further, there must be some evidence of the availability of the data to which the methodology is to be applied. So that sounds like quite a tall order. We need to set out how we're going to go about this, often without actually having any data, because we're not instructed by a client as in a normal case. We're not instructed by one's claimant that can give us any data or industry knowledge. So it can be quite tricky to figure out how this case is going to be done without actually having the benefit of that support. But that said, in practice, the test hasn't proved to be particularly challenging in the UK, at least since the Merrick's judgment came out by the Supreme Court Merrick's judgment here. There have been a range of class actions that have been certified, some even on the last day of the hearing, which sounds a bit like rubber stamping, which I think both Adam and David mentioned that shouldn't be the case. And there was a certain concern, I think, among practitioners that this is what is happening. But there have been some developments, I think, in this year in particular. There have been two cases where the CPOs were not granted. One was the Gormson versus Meta case, and the other one was the cases brought by Harkus Parker against both Visa and MasterCard in relation to various interchange fees. And I think it's worth kind of touching a bit on these cases and draw out the lessons that came from these. So I think it's worth noting that both of these cases were actually standalone cases. So as Mark mentioned, is that the problem wasn't just with the quantification of the damages, but actually in both cases the tribunal found that the experts hadn't clearly set out how they were going to about even establishing liability, let alone quantum. So it was actually, the cases failed at an earlier stage. And there's some specific guidance given, let's call it guidance by by the tribunal in the Gormson versus Meta case. The tribunal identified two fallacies that the expert had committed. The first fallacy was the St. Augustine fallacy, which rather colorful wording, but I think what the cat meant was to say you cannot just point at disclosure becoming available at some point and that disclosure is going to magically resolve every issue that you have. You need to actually specifically say what disclosure will be available and how that's going to address the problem. And the other fallacy that was identified was the not my problem fallacy. So that was the expert saying, well, this was an excessive pricing case, partially, and the expert set up the methodology based on previous cases, but there has never been an excessive pricing case in a two-sided market, and the defendants clearly criticized the methodology, and the claimant's expert hadn't sufficiently thought about it or set out how he was going to deal with this criticism and how to deal with an excessive pricing case in a two-sided market where you have prices across the two sides, and therefore everything becomes much more complex. And just briefly to note on the interchange cases, the similar issue has arisen. The expert hadn't properly set out how he's going to deal with liability, but also hadn't put forward a proportional methodology for pass-on. And pass-on is something that I will touch on a bit later.
Just wanted to touch upon one more thing, which is, this idea of, Mark mentioned, which is the idea of, kind of calculating aggregate damages, and then there's a question of, how do you actually distribute that, right? And who's actually harmed, figuring out who was actually harmed, and then making sure that, the class members are actually compensated. And there are interesting aspects there, especially talking about two-sided markets, for example, right? If you take credit cards, for example, there are rewards, right? So some people may actually, the high interchange fee you pay may actually result in you getting rewards. And so it's possible that some people would actually would have benefited from it. So I guess these things have to go to trial first. They've not gone, and we need to figure out how that shakes out. I'd like to now turn to methodologies in particular. Maybe perhaps discussing a few cases and thinking about what kind of methodology we are seeing in the field and what kind of lessons we can draw from those. So, Asker, could I ask you to begin?
Yes. Yes. What I wanted to do was to think a little bit about what it is that the economists are discussing when they are discussing in these cases, and think about the sort of the workhorse quantification method that we are using, which is the comparator-based method. So that be that we compare what happened during the infringement compared to another time after infringement in the same market, or we can compare across markets or across products, or we can make a combination of this. And the workhorse in these methods is the so-called regression analysis, because this has the feature that it allows us to control for other factors that could affect the market outcome. This methodology has been very nicely laid forward in the BritNet decision. And of course, the key question that you have heard many times, I guess, is what to control for when you use this method. And I thought it was quite interesting, formulated by Duff's economic expert in the Royal Mail decision recently in the spring, the CAT decision, where he said that in order to make a meaningful comparison of invoice prices between these periods, determinants of drug prices that are not related to the infringement need to be controlled for. It sounds pretty obvious at face value, but I actually think it can be misread, because there are two things that you need to think about when you are controlling. One thing is that you need to get rid of the noise in the data such that you can actually see if there is an infringement effect. But you also need to make sure that you are making things comparable. And strictly speaking, the only thing you need to do to make a meaningful comparison is to control for price determinants that are correlated with the so-called infringement indicator. That is all we need to do to make sure that we don't mask or exaggerate a potential infringement effect. This is what the so-called omitted variable bias is all about. So what it does is tells us that if we omit variables that are important for determining prices, that will only bias the estimate of the infringement effect if those variables are correlated in a statistical sense with the infringement indicator. Otherwise, we don't need to care about it. So what that says is that those variables that we want to use, they have to be systematically different during the infringement and after the infringement. So that's actually all you need to do, is to think about how you can make things more comparable. Otherwise, it will not make a difference. So it's essentially just removing hay from the haystack. So I can put this in context with sort of the truck case, because we can think about how to handle the fact that prices are correlated and sensitive to costs. But now, if to include cost in your model should have any merits, then it should be because costs are correlated with the infringement indicator. And what that essentially means in our setup is that it has to be systematically, the cost level systematically different during and outside the infringement. This is what it means in this broad axe approach that we are applying in these cases. And if it's not the case, then we actually don't need to take care of it. So what to do about it then? Because of course you may say that it is not enough not to take care of costs. So what you would want to do in that situation is that you would think about using external cost measures. Because if you introduce external cost measures, then you don't have any problems of feedback effects. If you insist on using internal cost measures, then you should think about, okay, if this internal cost measure actually changed my result, then how can that be? Well, that must be because this internal cost measure is correlated with the infringement indicator. So my internal cost level was different during and outside the cartel. And that again should make you think about how that can happen. And depending on your perspective on it, that might be an outcome of the cartel. So you have to think about how to handle that. We have methods in econometrics to handle these things, but sometimes it's just easier to try to do everything with so-called external cost measures, because then you don't get into these problems. You only have this omitted variable bias, but we usually know in which direction that runs. So this is sort of a lesson to think about when you are including variables in your comparison. Are these variables things that you use to take noise away, or the things used to take bias away? And this bias that you're taking away or adding on can actually take an infringement effect both in a negative and a positive direction.
Thanks, Oscar. And based on your work on these trucks cases, both in Norway and elsewhere, are there things that, differences or things that you see that may be worth?
I thought it was interesting to see the decision in the UK truck case with the Royal Mail, because you might read it as cutting the baby in half, but I don't read it like that. I think there was a very careful consideration by the court by both sides. I think the main issue in that case, also from my reading, was that maybe the economic experts could be a bit more willing to admit certain weaknesses of their approaches, but I think that the judges fully understood the pros and the cons and made a qualified decision. I think that was probably not the case in Norway, because the Norwegian court was not so experienced with these types of cases. And this sort of the decision there was mainly that the burden of proof had not been lifted.
It's an interesting thought I had while you were talking about, what factors actually end up affecting prices, and linking that to the truck's judgment where, there's obviously a big discussion about plausibility in that case. Mm. And if you, I don't know the details, I did not work on the case, but, from my understanding, it was actually shown or not sure, it was claimed that there was not real correlation between the exchange of information that happened on list prices and how that translated to actual transaction prices.
Yeah.
So how does how does an economist think about it in that case? Because here you have a situation where the claim itself is based on something that's actually an infringement that happened. And then if you look at the data and you don't really see a correlation, again, I haven't looked at it and I don't know, but if that is the case, how do you even think about?
I think in terms of here from the plausibility angle, here we are probably going from this by object decision that was made by the competition authority and whether that is enough to indicate an effect. And what the CAT decided was that it was enough to have plausible explanation why there could have been effect of this. And then it was up to the econometrics to actually show whether the effect was present or not.
Right. Yeah. And so if we don't pick up any effect, then how do, are we still saying that it's still plausible, but, or is there sufficient uncertainty around that result that we say that?
I think that the point of sort of having a sensible economic theory is that it has to be falsifiable.
Right.
Yeah. So we need to be able to conclude that there was no effect.
Right. Thanks for that. And, Felix, obviously one of the other important aspects of calculating damages is to think through pass-on. And, there's been some interesting kind of conflict type issues that have come around. So could you talk about that a little bit?
Yeah, I mean, there was always a risk of conflicts between different claims when it came to the question of pass-on. And that was already recognized in the European Commission's damage, the directive on quantifying damages, the damages directive. But I think that the CPO regime has amplified that because you now have, for example, the Merrick's case, which is brought on behalf of all UK consumers who ever bought anything in the UK, who are claiming that merchants paid interchange fees and passed these interchange fees on to consumers. But on the other hand, you have also the merchants claiming damages from Visa and MasterCard, claiming that they never did pass on these interchange fees to consumers. So therefore, you have this conflict there between individual claimants and the CPO. But that's not unique. You actually have also cases where you have conflicts between different CPO applicants. We have the App Store cases brought on behalf of app users and on app developers. So again, the question of pass-on is central to who's right, or at least how to distribute the damages across the two classes. And then you have the trucks case, the RHA claim that went to the Court of Appeal, where the Court of Appeal recognized the potential conflict even within the same class in terms of renting or buying a truck, and then told the CAT that it needs to sort that out somehow. So these conflicts when it comes to pass-on need to be kind of addressed. They are recognized, and the CAT is actually taking some pretty proactive steps in terms of addressing this, as has become clear in the interchange fee proceedings. So there are the umbrella interchange fee proceedings brought on behalf of hundreds of thousands of merchants, individual claims, and then there's Mr. Merrick's with the CPO on behalf of consumers. And what the CAT basically did is to say, well, there's a risk for conflict here, there's a risk for over and under compensation, so we're going to case manage these together. And also we are not going to go down the methodology route that we've used before. So just for context, in the UK, we had two judgments where pass-on was an issue. That's the Sainsbury's against MasterCard case, and then there was the recent trucks cases. And in both cases, pass-on was basically decided based on a detailed forensic review of all the internal pricing and budgetary decisions of the claimant to figure out whether somehow they took account of that overcharge and then spit it out at the end in terms of higher prices. And in this case, it doesn't work, was because Mr. Merrick's can't ask every merchant in the UK economy to disclose their pricing strategy and then figure out whether they passed on the interchange fee or not. And instead, the CAT said there needs to be some proportionate methodology that addresses this issue in the Merrick's case. But at the same time, there needs to be some consistency with that case and the individual cases brought by the merchants so that we don't run into the issue of having conflicting outcomes across these two cases. We are still in the process of figuring out how that's going to be done precisely. We're preparing for the third trial just on the issue of how we're going to deal with pass-on, not the actual pass-on hearing, but the third hearing on how pass-on is going to be dealt with from an evidence point of view at the moment. There have been 2 judgments already from the CAT on the issue, with some indications as to where as to likely direction. And in terms of methodology, the CAT clearly said it's not interested in the detailed forensic review of all the documents. It's also not interested in simulation approaches, interestingly. So kind of CAT said simulation is too complicated, too much assumption-based. But instead, the CAT has instructed the experts to consider the potential lessons that can be drawn from existing econometric studies or new econometric work inter alia. So we're still discussing where this is going to end up. But certainly quite a complex matter, and we'll know maybe by the end of next year where this is going.
That's very interesting. Mark, I mean, you spoke about pass-on, and we started off this conversation talking about the actual and the counterfactual, and the importance of that in calculating damages. There's also been some more novel kind of abuse allegations that we've seen in the CAT. Do you have any remarks on those with respect to actual versus counterfactual?
Yes, absolutely. So where would I begin? Well, so you said novel. I think novel has sometimes been used a bit pejoratively about some of these claims, and I mean, as an independent expert, I'm not going to take a view on what is really a policy question. So, but I think whatever label you give them, in some of these cases that have been called novel, there's a big role for the economist to estimate what that counterfactual scenario looks like. So I'll do a quick canter through some examples of some of the cases that have at least been seen in some quarters as a bit novel. The first one is the boundary fares cases. So the one-sentence summary of this is that, for anyone who doesn't know, is that these are cases where rail travellers purchased tickets into central London stations, and they also had travel cards within London, and technically they only needed to buy a ticket to the boundary of their travel card area, and that would have been cheaper. So the question that arises in that case is, what would these consumers have done in the counterfactual scenario? And in that case, the experts put forward a methodology based on a survey of rail travellers, among other things, but that element of the methodology was challenged by the defendants and challenged up to the Court of Appeal level. The Court of Appeal ultimately decided that a carefully designed survey with input from the expert would be a suitable methodology for considering the counterfactual in that case. A second example that is interesting is the case that's been brought by Which in relation to alleged conduct by Qualcomm inflating the prices allegedly of chips in smartphones. The claim, of course, then has an intermediate step through the smartphone manufacturers to the prices consumers, who are the class members, pay for their smartphones. Of course, a smartphone is a complicated open device that also changes over time.
System has a boundary
the element of that price that was increased by the price of the chips and not by other factors. This is effectively similar to what Asju was talking about a minute ago. And in that case, that is the CAT, I should say, has approved a methodology based on hedonic pricing, which sounds exotic, but really isn't. It's just a regression analysis where explanatory variables in your regression equation are observable characteristics of the phones. And third example that I think is quite interesting, a case that's actually not been filed yet, but has been quite widely announced, is there's a set of claims announced against UK water companies in relation to sewage discharges. It's alleged that they misreported their sewage discharges, and it must be, we don't know much about the claims, but it must be that they're alleging that absent, or had the sewage discharges been reported accurately, consumers would have paid less for their water. So that will necessitate, because of course it's a regulated monopoly, that will necessitate an assessment of the counterfactual regulated prices. We've seen a bit of assessment actually in the BT Royal Mail Trucks claims about regulated prices in relation to pass-on, but bringing a case that says in the counterfactual the regulated prices would have been different on an entirely standalone basis without the relevant regulator having agreed that they would, is also novel, and there'll need to be a methodology for that in that case. So that's really just a flavour of some cases. I could, talk out the rest of the panel, but I won't about the various cases. But yeah, surveys, hedonic pricing, regulatory related prices. There is a rich economic toolkit that we can call upon to assess counterfactuals in these matters, and I think even if these methodologies are less familiar in the competition litigation context, they are well grounded in economics and in the literature and in other disciplines. So I think there's a big role for economists in these novel cases.
So you mentioned surveys that could be run, and obviously the fundamental question here is, look at what would consumers have done, right? Had either some information been available, for example, in the trains case, or perhaps there was greater disclosure of some issue with the device. And you mentioned surveys. Are they the issue, however, is that how you design the survey clearly matters a lot. You don't want surveys are often subject to biases that we want to avoid. But if you think about a situation where, let's say, something that was not disclosed had been disclosed, it seems particularly problematic to think about, what a well-designed survey is going to ask respondents. And in a world where the expert does not have to, say that, or make clear, what that survey instrument is going to look like, it does seem like it's going to be, somewhat challenging to attach much certainty to what comes out of your survey design. And all of this may have to be, may all have to be dealt with at trial, but it seems like there's an issue there. I don't know if anyone has any comments to.
Yeah, maybe I can chip in. I mean, to me it seems particularly problematic that you have to run, that you cannot run this survey retrospectively, because that's essentially what you would really like to do, to find out what they would have done in that situation. But you have to ask people that are already tainted and have a share in a claim what they would have done. So in my opinion, you will probably have to find something, a similar market where you can run the survey and find out and use a comparator method to control for the difference between those markets.
That's right. And then just briefly touching upon, the idea of counterfactuals again. Felix, did you have any further thoughts to add on, thinking about counterfactuals, especially in excessive pricing cases? We're seeing quite a bit of that in front of the cat as well. Did you have any thoughts on that?
Yeah, I mean, we have seen the Gomes and Meta case did open up a lot of questions about counterfactuals, and particularly I think the problem was that three separate abuses or three separate infringements were identified, but only a single counterfactual was proposed. And in the end, the cut basically discarded two of the cases completely and just focused on the excessive pricing case. But yeah, I mean, just highlights how important it is to clearly spell out what actually the harm is supposed to be and how you're going to assess that in the counterfactual. And that there needs to be that you need to match the two together, and that there are no shortcuts to that.
Also, there's a challenge when you've got a bunch of firms are all selling what we call differentiated products, right, as economists, right? If you try to use comparator-based methods, you need to be careful that your comparators are actually suitable comparators, and that becomes and so then the question is, again, what would the prices have been absent the alleged excessive pricing abuse? It becomes a really tricky question, because now you've got, even if you look at other comparators and say that, their prices are X or Y, and, this firm's price should be similar to the others, well, they're all selling differentiated products, right? So and then, what is it that, what should the counterfactual non-abusive price be, which would still allow for some margin, right, for every firm because they're differentiated, becomes really.
I think there's been an interesting debate about this for a long time, which is, in an excessive pricing case, is the counterfactual just the price that is at the cusp of not being excessive? And I think the answer to that is no, because at least that's how I read the Albion Water case, which is now decades old. But I think the Albion Water case kind of set out that the counterfactual, that the relevant isn't question isn't what what would the just not excessive price have been, but it's rather what is a realistic price that would have been agreed in a commercial negotiation in that instance.
Connections and now the concept of introducing after.
So we've been speaking quite a bit about competition related issues. Does anyone have anything to add or say about calculating damages in non-competition related matters? Mark, do you have anything to add?
I'll just chip in quickly to draw the distinction really between the cases we've been talking about and the non-competition cases, which in the UK are under, I think, the CPR 19.6. Not really an area of cases that I'm very familiar with, but the key distinction that was drawn in the recent, in the Lloyd Google case, which was a couple of years ago. This was a case relating to what's called the Safari workaround, which was some tracking that Apple effectively implemented on iPhones. That Google implemented in relation to tracking iPhone users. What was alleged was a breach of Section 13 of the UK Data Protection Act, and Mr. Lloyd wanted to certify a class of claimants in relation to the harm they suffered from that. And there were a few reasons why that ultimately was not allowed to proceed, but one of the reasons was that the finding that there had to be, under that regime, individual assessments of damages. You couldn't just apply your actual framework at the class level. And that would be, I think, close to unviable, given the complexity
about systems and how they work.
Yeah, and based on some work we've done in the past, it seems like, broadly when you think about these data privacy cases, right, they fall into two buckets, right? You've got the invasion of privacy cases where there's some inherent value to data that's been claimed, and then you've got the data breach cases where they're saying, well, my data was not stored properly, and therefore, had there been some malicious actor, stealing that information, then, you're claiming essentially damages for potential harm flowing from that. And unsurprisingly, because there's no market for data as such, there's no legal market for data, you may have to go look at dark web prices or something if you want to look at, the value of data. But even then, it's not really clear whether that price is actually reflective of the true price at which, data is exchanged or bought and sold, and how it's actually put to use. But essentially, because that kind of a formal market doesn't exist, you end up often having to rely on things like, again, survey-based evidence, conjoint analyses, for example. That's another thing that's been proposed, where essentially consumers are asked to perform fictitious purchase decisions based on attributes that they see on the screen for different alternatives, and then a price is attached to the particular attribute that you're interested in. So it could be greater privacy, for example. But again, that again comes down to the question of what you mentioned, Mark, which is there's going to be an incredible amount of variation in terms of how much people value, right? And so how do you then take that? You have a methodology, but then it produces such variation that it's not really clear how you're going to compensate, people for the various damages that they're claiming. That's all I had. Maybe, we want to just quickly touch upon, since we have a couple of minutes, any experiences in, non-UK venues, Portugal, Netherlands, where there's quite a bit of action happening?
I can add a couple of sentences only.
Yeah.
I think, what's interesting in those regimes is they've got opt-out regimes similar to the one that we're operating here, but only similar in certain respects. And I think there's a key difference in procedure, which is they don't have a certification step before the substantive trial, as I understand it, in either Portugal or the Netherlands. So we don't have this process test that Felix was describing. And because we haven't had that, none of those cases has yet reached the substantive trial on the merits, so we don't actually know how the court will view the expert methodologies. We can assume the methodologies put forward will be similar to because effectively the UK is sort of forging ahead, but we don't know how the courts will see it yet.
Yeah, we've seen also the Netherlands, the App Store cases that we have filed in the UK, or that we supported in the UK, they've also been filed in the Netherlands and Portugal. And actually in the Netherlands, an interesting question there came up was with regards to pass-on as well, because we have, there's already an existing class action there that is brought on behalf of app users and app developers at the same time. So there's this conflict within the class issue again. Also, yet to be determined how that's going to be dealt with. I mean, there's clearly a lot of learning to be done over the next 10 years or so.
Thanks very much. I think we're 8 seconds there, but we have 5 minutes for any questions that people may have. Happy to take them.
Sorry. Copenhagen Economics. Mark, you mentioned in your remarks early on that basically you said there was a lack of investigatory powers that private enforcement practitioners, economists faced. To what extent do you see in the UK, for example, the possibility to request pre-certification disclosure as some kind of substitute for those powers? I think in the Forex case, for example, the CAT in the initial decision said that had an assertion been made that those kinds of pieces of information were required to be disclosed from respondents, then they would have taken that assertion seriously. But they didn't comment on further because such request was not made. But are there any blocks, whether procedural, psychological, any other blocks that economists might face in making that assertion?
So I will start by saying that some of that was slightly indistinct, so I didn't get 100% of it, but I will say something that I hope isn't irrelevant, and everyone will just nod anyway, that would be great. So I think you were talking about the lack of access to information and disclosure, and the challenge that presents to us, and whether there are ways to overcome that, and for example, ordering pre-certification disclosure, which did happen in one case that I was involved with recently, and ultimately that case has now been certified. And I don't think it's actually, I think it's a case-by-case assessment. I think it can be very helpful if there's a narrow and specific focus set of questions, but conscious of the case law that's been gone all the way up to the Supreme Court on this, we understand certification isn't supposed to be a mini trial, and getting disclosure starts to feel like a trial. I mean, I think, because this is the difference between your commercial court actions and your competition actions. In the commercial court action, which is standalone in the sense you do liability and damages together, but you also have the benefit of disclosure before you write your report. So it does feel like going too much towards a mini trial, but it can be very useful sometimes if there's a narrow and specific set of questions. I think the CAT does have in mind the requirements or the limitations on what the expert can do, and in their decision certifying that one, I did bring a third quotation with me. They said, we keep in mind the judge's words in the Gutman Trains case that certification prior to disclosure, the methodology is necessarily provisional, given the asymmetry between the parties. The tribunal is currently armed with a broad axe, which is to be adjusted to the context of the case. And they went on to say, we recognize the methodology may require refinement. So I think the CAT is going to apply a reasonable test and not require us to be overly precise, hopefully.
Any other questions?
I was just going to make a point of information. I think the Canadian Supreme Court decided a case at the same time as Microsoft's process. I can't remember the name.
We can't really hear what you're saying.
Yeah,
Sorry. The Canadian Supreme Court decided another case at the same time as Microsoft process, which I recall said that you could have certification of a class with more than one level of claimant and deal with the conflict issue later. So that's another way of cutting the cookie. Not one that the CAT seems minded to go down. I also understand that there is likely an appeal to what they said about the internal conflicts of interest within RHA in the trucks case.
Thanks for that. Anything else? No? If not, we'll give you back your 41 seconds. Thanks very much, Jerome.